Good morning. We still have people making their way in, but we will get started with our webinar here in just a moment. It is 10:30. All right, we have limited time this morning, so we're going to go ahead and get started. Good morning, I'm Kristen Glass. I'm the Chief Strategy Officer with the Quad Cities Chamber. Welcome to this morning's webinar. Happy you could all join us this morning. This morning's webinar is about supporting our workforce with Return to Learn, featuring Matt Pappas and Allison Wright from our local attorneys at law, Pappas Wright, a premier management, labor, and employment law firm serving Iowa and Illinois. They are our sponsors this morning, so thank you for your support. Thank you all for joining us today. We'll record this webinar and have it available on our website for you to find this information later. This year is the Quad Cities Chamber 10th anniversary. Many things have changed in 10 years, but one thing remains the same. We're here for you to support your business and our community. It's certainly an unusual time, and we appreciate everything you and your companies are doing to restart our economy. It's not only the 10th anniversary, but it also marks the beginning of a new era for our organization. We haven't changed our goals, which is to grow our GRP and population, but our path to get there looks a little bit different because of COVID. Over the last year, we've worked to streamline our organization and create efficiencies to maximize our impact on growth and our success of the community. We continue to be your go-to organization for business support, advocacy, and resources, and today's webinar is one example of how we're doing that. If time allows, at the end, we'll take some questions, so please make sure and type your questions in the chat box throughout, and we'll get to them in the end if time allows. It's now time to introduce today's speakers. Matt Pappas is the managing shareholder of Pappas Wright PC. Matt's focus areas include management labor, employment matters, and litigation with private and public sector clients, including local and national businesses, colleges and school districts, hospitals, medical corporations, municipalities, and financial institutions. Allison Wright is also a shareholder of Pappas Wright PC. Allison's focus areas of work include management labor, employment matters, and litigation with private and public sector clients, including local and national businesses, colleges and school districts, hospitals, medical corporations, municipalities, and financial institutions. Thank you, Pappas Wright, for being a longtime chamber member and for supporting us with the information today. Our members are grateful to be here, and we're going to go ahead and jump right in. Let's get started.
Thank you very much, Kristen, for the introduction, and many, obviously, heartfelt thanks to the Chamber for having Matt and I as part of your webinar series today. I think I speak on behalf of everyone in our firm and Chamber members and Quad City businesses when I say thank you for all the information and insight the Chamber has provided the members in the Quad City community during these very trying times. Today, I'm hoping Matt and I can contribute even in some small way as a source for some of that information. So for those of you who may have joined us back in March, we spoke after all of our worlds had been turned upside down about a new piece of legislation that was hot off the presses as of March 18th, and that law is the Families First Coronavirus Response Act. Given the time constraint and the fact that I don't want to screw it up too many times, I'm going to just call that the FFCRA today. Many businesses were required to learn all the nuances of a brand new and very complicated law, and in case that wasn't enough, since it went into effect on April 1st, as I'm sure many of you are aware, the Department of Labor has issued waves of new regulations, and then another wave, and then another wave, sometimes just 24 hours apart. So if you aren't too seasick from the ride just yet, today we're going to revisit the FFCRA and talk specifically about the 2 leave entitlements created under that law because it's becoming much more relevant again as we return to learn. So let's dive right in. The FFCRA creates 2 separate leave entitlements. One is through a new law, the Emergency Paid Sick Leave Act, and the other is actually an amendment to the FMLA that we're all used to dealing with. And it's called the FMLA Emergency Expansion Act. I'll just call that EFMLA today. Notably, while these are separate laws, they can be used a few different ways. They can be used completely separate, or they can be used together in conjunction with one another, meaning someone could use emergency paid sick to fund the initial 10 unpaid days of EFMLA. And we'll talk about that in a little bit more detail. But I've just given both provide paid leave. So 2 separate leave entitlements, and we're going to walk through those individually. But on this slide, I do cover some of the similarities between the two. They have the same effective dates. April 1st was when they became law. They both are set to expire as of December 31st, but most are not expecting to be over the COVID crisis, obviously, come this new year. So we're speculating that the act may be extended beyond that date. So we will, of course, provide an update if that occurs. And then some other examples, they both qualify for full reimbursement for the use of tax credits. They both provide leave to care for child while a school or a daycare is closed. Both permit intermittent use, and they both have maximum caps on what can be paid. So let's look at the Emergency Paid Sick Leave Act first. Who does it apply to? For a private entity, anybody with less than 500 employees. So if you're over that threshold, the act does not apply. And for public entities, it's with one or more employees. So there is some nuances between private and public there. And who does it cover? It's a very global rule, basically all of them. Any employee who works for the company, regardless of how long the employee has worked there. And you'll see that that's different than the EFMLA. Now, there are three primary exclusions under the Emergency Paid Sick Leave Act, as you see here: healthcare providers, emergency responders, and then the small business exception rule. And that is only for leave requests regarding school or daycare closures for businesses with less than 50 employees, when providing that leave would jeopardize the viability of the business as a going concern. It's a very fact-specific inquiry. I'm not going to cover it today because it requires a little bit more detail, but if anybody has specific questions about that, I can provide you the step analysis for that as well. And Matt's going to go through the healthcare provider definition in a little bit more detail when he speaks, because that definition was substantially changed a couple weeks ago. Now there's 6 reasons, technically 6 reasons, but really only 5, where an employee can take emergency paid sick leave, and they're here if the employee is subject to a federal, state, or local quarantine or isolation order that's related to COVID-19, if they've been advised by their healthcare provider to self-quarantine due to concerns for COVID, so those are people in those high-risk categories, or the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Seeking the medical diagnosis is a very important part of that. You know, I know some employers have the ability to get testing for their employees. And so seeking the diagnosis is exactly how you get that employee in the FFCRA paid leave entitlements. So sometimes that's a benefit to consider that. And then 4, 5, and 6, or 4 and 5 are really the most relevant. The Secretary of Health and Human Services has actually not announced any substantially similar condition yet. Well, so while 6 is on this slide and it's in the statute, I've included it here, it's really not relevant at this point. But then employees can get emergency paid sick leave to care for somebody who is subject to one of those quarantine or isolation orders, who's been advised by their healthcare provider to quarantine, or who's caring for their son or daughter because of school or daycare closures. So how much leave is available? Well, it depends if you're full-time or part-time. So full-time employees are going to be entitled to 80 hours of paid leave. So it's 2 weeks. And then part-time employees are entitled to the average number of hours the employee works over a 2-week period of time. Now, we've spent a lot of time advising clients about varying schedules. So if you are unable to determine with certainty, that's the standard from the DOL, the number of hours that would have been worked, then there's 2 standards that you use to figure that number out. If the employee's been employed for over 6 months, use the 6-month average of hours worked. And if they've been employed less than 6 months, then you use the reasonable expectation at the time of hire of how many hours they were going to be working. These are the total amounts provided. They can be used all at once, so you could take 2 weeks off at one time if you're a full-time employee. It was intended to cover that 14-day quarantine period. And it can be used all at once, or you could use it in increments as well. And how much do you pay? So in very lawyerly fashion, the response to that is it depends. And it depends on the reason for leave. So this chart here breaks down that it depends response. If they're taking leave for one of the reasons 1, 2, and 3, which is specific to the employee themselves, they're actually entitled to be paid their full regular rate of compensation. But if they're taking leave because they're caring for somebody else in one of those situations, they're going to get paid at 2/3 that regular rate. And both of those are subject to maximum caps, which I've also included in the chart. So when they're getting paid for the full regular rate, that's a max of $511 per day, or $5,110 over that 2-week period of time. And then if they're taking leave for caring for somebody else, it's $200 a day, or $2,000 in the aggregate. Now we're going to move and talk about the second leave entitlement, the emergency FMLA. And the reason I've included this slide, I do want to point out that the EFMLA was an amendment to the traditional FMLA that we're all used to dealing with. We've received many questions, and I know this was one of the first burning questions we dealt with in March, asking if EFMLA is actually a separate 12-week entitlement under the FMLA. So here on this slide, we just think it helps to include the exact language to show that it's listed as one of the other qualifying reasons that entitle someone to FMLA leave. So there's quite a few differences between traditional FMLA and EFMLA, but they all fall underneath one large FMLA umbrella, which means employees are entitled to one total 12-week bank of FMLA leave. So if they used 12 weeks of FMLA before they ever needed to seek EFMLA to stay home with their kids who may be attending a school district that's fully remote, that employee has actually exhausted all of their FMLA and would not be entitled to any EFMLA at this time. So who does it apply to? Any employer with less than 500 employees. And you'll see in a chart that I have distinguishing the differences between traditional FMLA and emergency, that there are going to be some that are covered and required to provide emergency FMLA who have otherwise never dealt with FMLA leave at all. Who does it cover? This one's different than the emergency paid sick because it covers any employee who's been employed for at least 30 calendar days. So there is some level of employment there, and the same exclusions apply. Healthcare providers, emergency responders, and that small business exception can be included. It's a discretionary decision. It does not mean that they cannot be entitled or paid that leave. So I kind of break the definition down for EFMLA. There's only one reason, but there's different components to it. So first, they have to be unable to work because they have to care for their son or daughter who's under age 18, because the school or place of care has been closed or the child care provider is unavailable due to COVID-19. Now, school is defined to include elementary and secondary schools. A child care provider is actually defined as somebody who receives compensation for providing child care services on a regular basis. And it can include daycares, preschools, or in-home daycare, or even at your own home. And then child has to be under age 18. But what we saw the IRS and the DOL do after that is come out with specific rules for children aged 14 to 17. And if they need care during daylight hours, an employee is actually going to have to show special circumstances to substantiate the need for care during that time for that age group. So we already talked about this a little bit. How much leave is available? 12 total weeks of protected leave under FMLA. The first 2 weeks are unpaid. So the first 10 days are unpaid, and then they get 10 weeks of paid leave. So there's one 12-week FMLA entitlement, like we said. And an employee can elect to substitute accrued vacation leave, personal leave, or medical or sick leave for that unpaid 10-day period of time. And that is also where you'll see the two statutes kind of correspond and speak to one another. Some will use the emergency paid sick before they use emergency FMLA. So how much do you pay? This one's a little bit more black and white. There's only one rate that applies under the emergency FMLA, and that is 2/3 the regular rate of compensation. Also subject to daily and aggregate caps. So the max is $200 a day, and that's $10,000 over that 10-week period of time. So I talked a little bit and touched on traditional FMLA. I won't go through this chart in detail in the interest of time, but it just shows some of the ways some employers may be dealing with FMLA for the first time, who's covered, who's not, what types of leave are available, and what the eligibility requirements are. It gives a little side-by-side of some of those key differences. And then on this next slide, you'll see this is actually a complete summary of all the information I just gave you about the Emergency FMLA and Emergency Paid Sick Leave Act. We have used this chart extensively, kind of as a quick tool guide to refer to when you are kind of seeing what the standards are, what the requirements are, and eligibility requirements for both of those statutes. So print this slide, use it if you want, but it just summarizes the different leave entitlements that we just talked about. And so Matt is going to go through some of the new nuances from the DOL, again, giving us a wave of guidance with a new rule just recently on September 16th.
Well, thank you, Allison, and thank you for giving me an opportunity to show my radio voice, not my made-for-TV face, because that's not. Anyway, apologize for that. Anyway, I'd like to talk to you real quick about the DOL and what the DOL has been up to. Remember that the FFCRA was the fastest complex bill creation from inception to passing. The president signed it on March 18th. April Fool's Day was when the final rules were in place. April 14th, the state of New York filed a lawsuit saying that this law should be not used because of some nuances about that. But then really the nuances for for New York, for them to talk about, everybody was kind of going, well, who cares? New York, that's New York. Well, you should care because these things became nationwide. And on August 3rd, the decision was made. And then September 11th, the revised rules, and September 16th, the effective revised rules. And now for the next 2 months to go, we have these guidance for us to go through. Why is this important? Again, where the district court order vacating certain provisions of FFCRA paid leave regulations apply, it was nationwide. Based on the circumstances in the case language of the district court order, the department considers the invalidated provisions of the FFCRA paid leave regulations vacated nationwide, just not as to the parties in the case. Next slide. On April 14th, 2020, the state of state of New York filed suit in the United States District Court for the Southern District of New York, challenging certain parts of the temporary rule. The decision struck down 4 provisions of the Wage and Hour Division, Department of Labor's final rule implementing the elements of FFCRA. They were the work availability, whether or not you need to have work available to obtain benefits, intermittent leave, whether or not you have to have approval of your employer or not, documentation, when and how much, and as Allie had alluded to earlier, healthcare provider was completely changed, and that was the major part. So the question really became one, once you had the decision, do you appeal or do you rewrite the regulations? They rewrote the regulations. And of course, we get more and more. There's 103 questions that are answered, Q&As that are answered on the DOL's website that address a lot of the questions that you all have, but now we have more and they're more detailed. So the appeal or address, we reaffirmed, so what the court or what the department did is they reaffirmed, revised, and explained. So as to work availability, as Allison explained earlier, the FFCRA grants paid leave due to because of any of the 6 qualifying conditions. In those conditions, I'm not going to go repeat those. And then in the case of the emergency family medical leave expansion, unable to work due to a need to leave care for a child due to COVID-19. The final rule implementing both provisions excludes these benefits from whose employers do not have work for them. It imposes work availability requirement on those seeking to take paid leave for certain conditions. The court struck the word work availability rule on grounds that the Department of Labor had provided insufficient justification for its inclusion into the final rule and characterized the USDOL's bare bones explanation for work availability requirement as patently deficient. In support of this reasoning, the employee may need to take a job protected leave even when an employer has no work for the employee, and gave the example of a teacher on parental leave who may still be considered on leave even if the school is called off for a snow day. The department reaffirmed the paid sick leave and expanded family medical leave may be taken only if the employee has work from which to take the leave, and explains further why this requirement is appropriate. This temporary rule clarifies this requirement. It's important that it was important to know that they have to have that work has to be available, because if you don't have that situation, you're having individuals saying, you know what, my business is closed, and then I'm still responsible for paying out benefits. That's not the case. This is important because the rule was welcome relief to cash-strapped employers facing the prospects of paid leave requests when employers and while their establishments remain closed. Intermittent leave, it's interesting with intermittent leave is not mentioned in the FFCRA. The USDOL's final rule permitted employers to take either the emergency paid sick leave or the emergency FMLA leave on an intermittent basis, provided such usage did not pose a public health risk and it's subject to the employer's agreement. So you had to have an employer that would affirmatively agree to and say, yes, we can go intermittently. The judge, though, found that while the prohibitions on intermittent leave for conditions were logically correlated with a high risk of viral infection are sound, he said they were sound, they do not justify conditioning intermittent leave on employer consent for the remaining qualifying conditions. Situations where an parent must stay home because the child's school is closed, which coincidentally do not implicate the same public health considerations. The department said, you know what, Judge, this is not the way we're going. We're going to stick to our guns and we're going to reaffirm that the intermittent FFCRA leave is permitted by the department's regulations. An employee must obtain his or her employer's approval to take paid sick leave for an expanded FMLA leave intermittently under the relevant section. This is a two-step process when responding to employees for notice for leave under the EFMLA. First, they must determine whether the request is for intermittent as opposed to several discrete days of leave under applicable guidance. And second, if it is or such a request, they may engage in a dialogue with the employee to see if the alternate work arrangements are feasible. Documentation. The next rule had to do with documentation, and the judge went crazy. Said, you know, you have different requirements for documentation under both acts. Well, the EFMLA, where the need was leave was foreseeable, shall provide the employer with such notice of leave as is practicable. In the emergency emergency leave, after the first workday or portion thereof, the employee receives paid sick time under the act. An employer may require an employee to follow reasonable notice procedures in order to continue receiving such paid sick time. The court found to the extent that the final rule's documentation imposes different or more stringent preconditions to leave, it's inconsistent with the statute and therefore cannot stand. So the department revised to clarify that the information the employee must give to support the need for his or her leave should be provided to the employer as soon as practicable. Secondly, the department revises to correct any inconsistency regarding whether an employee may be required to give notice to expanded medical leave to his or her employer. So the best practice, diligently collect the paperwork. You need to make sure that you're collecting the paperwork to support any FFCRA leave to ensure that they have the information necessary to support the tax credit. But the employer, the second point is more important, should not, however, delay any FFCRA leave due to employers' failure to provide the paperwork in advance. The next change, the next striking that happened was the biggest one, the healthcare provider. When initially the healthcare provider rule came into play, saying that healthcare providers were not entitled to leave. That was blanket. That was a blanket that helped everybody in the healthcare industry to assume that means everybody and anybody. It meant custodians. It meant IT people. It meant everything. So for the purposes of the exclusion of the FFRCR's coverage, the final rule defines healthcare provider as anyone employed at any of certain enumerated institutions, provided the medical care, and any individual employed by the entity that contracts with the aforementioned institutions. So it was more of a job or employer-based ruling, employer-focused. The court then challenged it and said, no, it's vastly overbroad, and the DOL agreed, and they revised it. The department revised the definition of healthcare provider to mean employees who are healthcare providers mirroring the FMLA in part, and other employees who are employed to provide diagnostic services, preventive services, treatment services, or other services that integrate and necessary provision of patient care. So in excluded specifically IT professionals, building maintenance staff, human resources personnel, food service workers, records managers, and billers, and provide services that affect but are not integrated into the provision of patient care. But included in that, and this is where it gets so wonky, and that's a nice legal term, wonky, is that medical doctors, nurse practitioners, and other licensed healthcare professionals, as well as employees providing services under the direction of or providing direct assistance to such a professional. Employees who are otherwise integrated in necessary provision of healthcare services, such as laboratory technicians who process test results and necessary to diagnose and treat. The revised regulations provide further an illustrated list of health services, if not provided, would adversely impact patient care, including bathing, dressing, hand feeding, taking vital signs, setting up medical equipment for procedures and transporting patients and samples. The revised regulations further specify that a healthcare provider may work at a variety of locations, including, for example, a doctor's office, clinic, laboratory, testing facility, or nursing home. However, an employee does not need to work at one of these facilities to be a healthcare provider. And working at one of these facilities does not necessarily mean the employee is a healthcare provider integrated into the provision of the patient care. So it's an analysis. It's an analysis. It's not, there is no bright line test, and you have to go in and take a look at these individually. The next point that I wanted to talk about real quick and briefly is the remote working. We've had a lot of people that have asked for their clients to remotely work. 50% of all adult workers were working from home in April of this year. The new normal, whether the pandemic telework creates a presumption to the right of post-pandemic work as a reasonable accommodation with employees with disabilities, is a question that was answered by the EEOC. The EEOC said in September they answered no to that burning question and updated the technical assistance questions and answers on issues dealing with COVID and the ADA and other equal employment opportunity laws. But the courts suggest differently. The courts still consider that giving somebody the ability to work, telework, could serve as a trial period that showed whether or not an employee with a disability could satisfactorily perform all essential functions while working remotely. The employer should consider any new requests in light of this transformation. So advice, how do we advise clients to respond to requests from employees who work remotely, including a situation where an employee request seems to be based on discomfort or fear of returning to the work site? The situation can be pretty dicey if the employer has been allowing the employee or coworker to work temporarily after the pandemic first hit. The consensus is that the employers need to assess requests carefully and methodically on an individual basis to engage in an interactive process, if for no other reason to get clarity as to whether an employee is basing a request on a disability identified by a healthcare provider as defined under the FMLA, not as defined under the Act, versus an employee's subjective preference for self-diagnosis. Also, don't overlook state and local orders for guidance that provide protection to certain classes of workers who are arguably restricted from working on site. Top three things to remember when granting remote work during COVID: make sure that you tell them that it's being granted specifically in response to COVID pandemic, clarify that it is intended to be temporary, and notify the employee that it can be revoked at any time. Thank you.
So as Matt just talked about working remotely, it's pretty clear right now in this return to learn era, as it's kind of been called, that employee requests are going to come in a lot of different shapes and sizes. So you've got different paid leave entitlements. There's some different nuances for those requests to work remotely. And then there's kind of this overlap, and then it complicates things that we're not looking at the traditional school structure that we're used to, where you drop your kids off or your kids are bused to school 5 days a week. Your workforce and your employees who are parents with school-age children are dealing with very complicated models. Some of them are fully remote, some of them are all in person, some of them are hybrid, some of them are up to parent choice. But it's interesting to see, and you absolutely need to know, the way the DOL treats return to learn, what those structures mean as far as paid leave entitlements go. So here's these are a breakdown of the rules. Like I said, there's different formats and every school district is different. There's really one rule that applies globally to all of these. If there is any day that a child can attend in person, and that child means specific to the employee, because we do know that there's these alternating Tuesday, Thursday, and then the next week, Monday, Wednesday, Friday. Any day that that child can attend in-person instruction in the school district, the school is not considered closed under the FFCRA. So this parent's choice option, a school is never going to be closed when the child could attend and the parent chooses remote learning. So for children who've gone fully remote, they will only be entitled to FFCRA leave as an employee on those days that their child otherwise wouldn't be able to. So it's very important. It gets very complicated for all your different employees and for your workforces to understand what school districts are offering. So quickly, I'm going to run through a couple of examples that we have that kind of meshes some of these considerations together. So for this first employee requests to be home to help 2 children ages 7 and 10 with remote learning. The school is offering in-person instruction 5 days a week. Parents have the option to do all in-person, a hybrid schedule, or fully remote. The employee is asking to be off on Tuesdays and Thursdays each week to help with remote learning and to care for children. So is this employee going to qualify for FFCRA leave? So let's start with the Emergency Paid Sick Leave Act. No. And under the Emergency FMLA, no. The reason for that, the school is offering in-person instruction 5 days a week, so the school is not considered closed on any day. Employee number 2, some similar. Employee requests to be home to help 2 children ages 7 and 10 with remote learning. The school is offering in-person instruction 3 days a week, Monday, Wednesday, Friday. Parents have the option to do a fully remote schedule, but they also have the option to send their children in person for those 3 days of face-to-face instruction. The employee is asking to be off on Tuesdays and Thursdays each week to help with remote learning and to care for her children. Is this employee going to qualify for FFCRA leave? Let's start with the Emergency Paid Sick Leave Act. Yes. And under Emergency FMLA, also yes. The school is offering in-person instruction in this example only 3 days a week. So it's considered closed on Tuesdays and Thursdays when the students cannot attend in person. And both the Emergency Paid Sick Leave Act and EFMLA are going to be available for that employee's request for those Tuesday, Thursday absences. In our third example, an employee requests to be home to help 2 children ages 15 and 17 with remote learning 3 days a week. The school offers in-person instruction 2 days a week on Tuesdays and Thursdays. Parents have the option to do either hybrid or fully remote. And the employee is asking to be off Monday, Wednesday, and Friday each week to help their children with remote learning. Same question, obviously, we start with emergency paid sick, and the answer is no. Emergency FMLA is also no, because while the school is considered closed according to the DOL on Monday, Wednesday, Friday, the children in this example are ages 15 and 17, and I intentionally did not include any special circumstances which would necessitate or establish the need for caring for children of that age. So this example could change if additional special circumstances per the DOL and IRS guidance are established by that employee, but based on the example alone that I've given, the answer would be no to both of those. For employee number 4, the employee requests to be home to help her child age 9 with remote learning. The school offers in-person instruction 5 days a week. Parents have the option to do all in-person, hybrid, or fully remote. The employee's child is currently undergoing cancer treatments and has been advised by her healthcare provider to self-quarantine. The employee is asking to work remotely 3 days a week while she and her spouse alternate caring for their child at home. So qualifying for FFCRA leave, let's start with emergency paid sick, and the answer for that is no. And under the emergency FMLA, the answer is also no. The employee here is actually not asking for leave. If we go back to the example, you'll see that she's asking to work remotely for those 3 days. And so, like I said, a lot of employee requests are going to come in a lot of different shapes and sizes. If they asked for leave, would they qualify for it? We'll talk about that in an example in a minute. But no FFCRA leave is actually even at issue here. So you want to evaluate whether remote work is feasible. And you would recommend that if you can set up a remote working arrangement, you follow those 3 guidelines that Matt talked about. First and foremost, letting them know that this is being granted because of the COVID-19 pandemic, that it's intended to be temporary, and that you could revoke that arrangement at any time. Employee number 5, the employee requests 3 weeks of leave off because his child, who is age 11, was identified as a close contact of a positive student in the child's class. The child has been directed to quarantine for 14 days. The child's school was offering in-person instruction 5 days a week, but announced it's going to go fully remote 2 weeks from the date the child was notified because of a larger outbreak, I'm sure. So qualify for FFCRA leave under the Emergency Paid Sick Leave Act, yes, and under Emergency FMLA, yes, but not at the same time. Here, the employee is asking for leave to care for someone who has been directed to quarantine, so that he is entitled to the emergency paid sick leave for that 2-week quarantine period of time. After that, the school is going to be closed per the announcement and under the FFCRA because it's going fully remote. So the employee could then transfer to EFMLA for that 3rd week of leave requested. So you'll be using both statutes in that example. Number 6, the employee requests to be home to help her child age 9 with remote learning. The school offers in-person instruction 5 days a week, and parents have the option to do all in-person, hybrid, or fully remote. The employee's child is currently undergoing cancer treatments and has been advised by her healthcare provider to self-quarantine. The employee is asking for leave 3 days a week while she and her spouse alternate caring for the child at home. So this employee is going to qualify for the emergency paid sick and will not qualify for the emergency FMLA because that is only for school closures. So here the employee is asking for leave to care for someone who's been advised by her medical care provider to self-quarantine due to the cancer treatments. So she would be entitled to the emergency paid sick leave regardless of whether the school was considered open or closed. Employee number 7 is requesting to be home to help her child with remote learning. She's employed as a nurse practitioner at a hospital. Now the school is fully remote for the fall semester, is not offering any in-person instruction, and the employee is asking for leave 3 days a week so she and her spouse can alternate caring for their child at home. Now under this one has much more of a lawyer response to it. Both answers are maybe. As Matt pointed out, an employee can be excluded as a healthcare provider and a nurse practitioner is involved in the direct patient care. Is certainly going to meet even the new definition of that from the DOL, but it can be excluded from both. So the employer does not have to exclude that employee. It is a discretionary decision to be made at the time of the request, or if the employer has the healthcare provider or the employer has a policy in place, they're just going to want to make sure they follow that. So if they take a firm stance at the beginning to exclude these groups, they're going to need to follow that. Very briefly, as a note on COVID positives in the workplace, you know, you hear the word contact tracing and you think of it in a Department of Public Health. That's kind of their thing. And of course, the definition was derived from, you know, the CDC and our public health departments, but it actually means a whole heck of a lot to businesses and employers because OSHA has confirmed that COVID-19 is a workplace hazard. So we need to take steps to not only prevent it, but also address it when you have a positive in your workplace. So big picture, your goal is to identify close contacts in the workplace and then address impacted areas. Now, the definition of close contact has changed, especially for March and even this summer. The current definition is being within 6 feet of an infected person for 15 minutes or more during the potentially contagious period, which is 48 hours before symptom onset or 48 hours before the positive test, if it's an asymptomatic positive. The definition used to have as a mitigating factor that if one or both individuals were wearing PPE or a mask, they would not meet the definition, and the CDC is no longer following that definition. So this is regardless of whether one or both individuals are wearing a mask. I do note in Iowa that the Department of Public Health just recently issued guidance resurging and kind of breathing new life into that previous definition, and they are using masks as a mitigating factor. So as kind of a cautionary point, OSHA is using, they describe it as the golden rule or the golden standard. The CDC guidelines is what OSHA follows. So from a workplace hazard perspective, to rely on guidance inconsistent with the CDC certainly poses legal risk. So step 1 for identifying internal contact tracing, you're not going to leave everything up to the public health department. You want to act swiftly as well as they are. They may identify some of your own employees as a close contact and you'll be directed to remove them, but don't leave it up to them. If you know that your employee, you find out someone was a positive and you need to remove them from the workplace, you should take action immediately to do that. And then address impacted areas by shutting them down if you can. The CDC recommends closing an area where somebody who was sick was in for up to 24 hours, if feasible, depending on how long you can, before you even start that cleaning process, but it certainly gets a heightened disinfectant standard. And once a close contact is identified, you want to consider the totality of the circumstances, remove them from the workplace, consider transitioning them to remote work. That helps promote productivity and also allows them to continue working. Place them on leave, obviously, if that's not an option, and then you'll monitor them for symptoms and illness and follow your return to work process as far as that's concerned for when they're able to return. So just a couple key points on positives as the cases continue to increase across the country and in the United States. So I know we're over the time, but like we said before, if you guys submit written questions or have questions about the presentation, you'll have these materials. Matt and I'd be happy to answer those.
Thank you, Matt and Allison. I appreciate the time that you've taken to help us through this, and also for your sponsorship of this event to allow us to do this webinar for free. We do have a couple of questions, if we can just answer them real quick. So the first one, we have a DBA out of North Carolina. They only have 20 employees. Since they operate under our tax ID, would they be able to be considered a small business under 50 employees, or would the employees be lumped into theirs, and are they therefore not able to be exempt? So would the DBA be exempt?
Sorry, just if you could you repeat the first part of that question?
They have a DBA out of North Carolina, and they only have 20 employees in the DBA. Since they operate under this company's tax ID, would they be able to be considered a small business, the DBA, or would they be lumped into the entire company that has the same tax ID?
The analysis is very different from different parts of the rule. FFFCRA, different passages of regarding PPP. There's a lot of different analysis that needs to go into that. And without more information, I don't think I'd be able to answer that right now.
Okay. Couple quick other ones. What happens when an employee uses their paid 2 weeks of leave due to their diagnosis of COVID-19 and then has another potential illness that keeps them out of work? Does this fall under FMLA? What if this person gets diagnosed with COVID-19 again, and they have already used their 80 hours of FFCRA leave?
So currently, the emergency paid sick leave is a one-time bank of the up to 80 hours if you're a full-time employee. Once you exhaust it, there's no entitlement, even if you have multiple reasons that re-come up. You would have to fall under whatever the employer's regular leave policies are. And it's important to remember for EFMLA that is only to take care of your children under the age of 18 for school or daycare closures. So that's a very limited rule. So, the DOL, the IRS, and all the state agencies are really recommending what businesses can do to kind of help our workforces right now is offer flexibility with your leave policies. And some have created, with our clients, some have created new leave entitlements. Some are allowing them to kind of universally use banks for whatever situations may come up with that. And that is certainly recommended. In union settings, of course, you need to walk through memorandums of understanding and working with our unions as far as getting agreement on that. But it is a one-time bank, to answer the question really directly. Once it's exhausted, for now, there is no further entitlement under that. If you become seriously ill with COVID-19, you may, or if you're caring for, an immediate family member, there is, law to suggest you may actually qualify for a traditional FMLA leave as far as that's concerned, but as everybody knows, that's unpaid. So it's not always necessarily that helpful. So it's kind of, once you exhaust that, if you're not going to be under EFMLA for school or daycare closure, you're looking at your leave entitlements from the business directly.
I'm just going to we have 2 more questions. I'm going to try to get to them pretty quickly. The age at which a parent is unable to use EPSL and EFMLA, what is that age?
So the child has to be under the age of 18, but then there's a nuance for that as well. For the ages of 14 to 17, the IRS actually came out and said during daylight hours, so if your employee works kind of a 9 to 5 shift, and they want to take leave off for a child within, that's why I used 15 and 17 in that example. The age is 14 to 17. If they have children that are age 14 to 17 who are at home and they're requesting leave to be home with them during ordinary daylight hours, that's where that special circumstances comes up. And I see there's a question on here too about is there further clarification on that? And there's not. right now for necessarily what that looks like. We do know as a general rule to just kind of say that they need my help isn't going to be enough justification for that. So we have seen those requests come in, but to say that, is that defined by the IRS? No, not yet. I think they're kind of leaving that as far as employer discretion if they do think that there are some circumstances for that. But they have spoken directly on issues with remote learning, that they're having problems at home and they need a parent there to monitor that. And what we're getting right now is suggestions from the DOL that in and of itself is not a sufficient justification right now. They'd have to change course on that.
And we have to remember too, is that we're dealing with different agencies. We're dealing with the IRS versus the Department of Labor, and there's different analysis for both.
Okay, it is 11:15. I really appreciate the work and time you put into this, Matt and Allie. Very helpful information for our businesses. Pappas Wright, Attorneys at Law, great resource for you. We will provide the slides on our website afterwards. Thank you again for your sponsorship, and thank you everyone for participating in today's webinar. We will continue to be here for you throughout all of the changes that are coming your way. Visit our website, quadcitieschamber.com. There's always great resources right there on our website. Everyone have a great Friday and enjoy your weekend.
Have a good weekend, everyone. Thank you for your time.
Thank you.